Last hour, and we'll get you out of here promptly at 4:15. So what we're going to cover now is mostly going to be immigration enforcement. So we spent the whole morning talking about CIS and how nice it was going to be to get everyone their green cards. And now this afternoon we're going to talk about the other side of it, which is the removal proceedings and ICE immigration detention. And I suspect for most of you, I'm going to cover how this process goes forward for children who the government's trying to remove, and I'm also going to talk about it as it relates to adults. I would suspect that in most of your cases, to the extent that you're dealing with people who are in danger of being deported, it's probably mostly adults that you're seeing, maybe the parents of the children on the cases you have. But again, I'll go over it with you for parents, for children and adults, the process both ways. So the first thing for us to know is that ICE has acknowledged it is not possible for them to deport all of the undocumented people in the US. And it's just, it's just reality that we all everyone can agree with. And so we have a memo from the head of ICE that has articulated their enforcement priorities. And ICE has, I think in the memo, has stated that the federal government basically has a capacity to deport about 400,000 people a year. And under President Obama, they are happily meeting those goals, but they're not going to deport everyone. And so in a world of limited enforcement resources, certain decisions have to be made about who are you going to target or prioritize. And so the people I've listed here are the general categories of people that are among the more high priorities for enforcement activities. And those include people who pose a danger to national security. A lot of these cases, they will say we are prioritizing terrorists, people who are trying to overthrow the United States government. But there is also a provision for people who threaten public safety, and I think those are more likely to be cases of more simple criminal convictions, violent crimes, DUIs, things that create danger to the public, even if they're not terrorist-related dangers. And again, here, one of the priorities in that category are people who are 16 or older who are involved in gangs. So certainly some of the kids perhaps that you are working with may fall into that category. People who are really recently entered the US, and most of that means you find someone who has just crossed the border or very recently crossed the border and you're going to be sending them back. And then we also have people who are fugitives or have otherwise obstructed immigration controls, and I think that generally is referring to people who may have outstanding deportation orders or people who continually get removed and keep coming back no matter what. So those are the areas of priority for ICE. ICE has acknowledged that it needs to take special care when it's dealing with any kind of enforcement actions that may advertently or inadvertently sweep up juveniles. It's very common, and we're going to talk more about people who are picked up by ICE through criminal court proceedings and the ties between ICE and the criminal courts. But it's also true that DHS finds people in a whole variety of ways. And I think here, obviously in borders and ports of entry and being turned over by law enforcement, I think something that my sense in Nebraska has happened several times, and certainly a high profile case in 2006, are ICE raids on workplaces. And particularly I think in the 2006 raid was in Grand Island, and it was a Swift meatpacking plant. So there have been targeted workplace enforcement raids by ICE where people are not necessarily being picked up for prior immigration violations or outstanding removal orders, or even being targeted because they have criminal convictions. They're being targeted as a way to punish them for working illegally. Some people are actually federally prosecuted for identity theft if they've used someone else's social security number. And I think perhaps to send some wider message about the government's getting tough on immigration. So there are a whole range of ways. I think the Swift and Company raid in 2006 was part of something called Operation Wagon Train that the government had, where they were targeting meatpacking plants around the country. But what we're going to focus on, because it's a pretty common thing, is for people who end up on the radar of the Immigration Service because they get involved with the criminal justice system. And so if you hear that someone has an ICE hold or a detainer, what it is an instruction from ICE to local law enforcement. And it's saying, we know you have this person and we want you to give us this person, or we want to have the option to take this person into custody when you're done with them. And so I've put at page 111 a copy of a detainer, so you know what it looks like. In this particular case, this was actually, let's see who we have here. I think this was a detainer issued against a juvenile, but the detainer form is the same for juveniles or adults, and you can just, it's a one-page form, and basically is directed, as I said, to the state or local law enforcement saying, you are advised that, even their forms say INS, this is like sad, but, years after there's no INS, but you're advised that INS, once it has, you have this person, and we're requesting that you hold this person to allow for their being picked up by ICE if we choose to do it. Not every person who gets a hold is actually going to be picked up by ICE. And for those of you who represent children or adults on the criminal or delinquency side, it's really important for you to know this rule. The detainer is only good for 48 hours after the person would otherwise be released from state custody. This excludes holidays and weekends. So if you have a child with an immigration hold and he's served his time in juvenile hall, he'd otherwise go back to his grandmother. If he has an ICE hold, you start the clock the minute he would otherwise be released, and the clock goes off 48 hours later, and at that 48-hour minute, you want that child out of state custody, or you want that adult out of state custody. Because at that point, the person is being held. If there's no legitimate state basis to hold them, and the detainer has expired, there is no lawful basis for them being held, and people have successfully filed habeas petitions to get released from state institutions where there's a belief that the detainer is a never-ending gift that keeps on giving for weeks after a person would be released. So I've put in the detainer as a 48-hour rule, and I've also in the materials on page 113 given you a copy of the federal reg that shows the time limit, and that's 112, 113. What was the question?
I was wondering about reissuing the detainer after 48 hours.
So the question is whether you could reissue the detainer. I don't know of any provision that allows ICE to extend the regulatory time frame because they're able to issue the detainer and then it's good for a certain amount of time. I don't believe, and I've never had ICE try to do it, I don't know that ICE really has the authority during the detainer period to issue another detainer. I've never seen them do it. I think they could try to do it, but I think there could be some basis for challenging that attempt. I think the reality is that if ICE wants to come get the person, if the person's a high priority, they will show up in the 48 hours. And if they don't show up, it's theoretically possible ICE could go to their home and find them, but usually the place it's easiest for them to catch the person is inside a state facility. So I haven't had ICE try to do that. I think that what ICE wants is a good heads up on when they think the person's going to be released, but I've never had them try to extend it. Certainly if all they said was, we're ICE and we're extending it, I don't think that would be good enough because they have a clear regulatory framework. And so I would argue that's all they have.
In your experience, the jails know about this, or are they just going to hold them until you apply for your agency?
You should assume that they don't know. And it would be charitable to think that they don't know, and they may not know, but it's on the face of the detainer. But it's the kind of form where you feel like, oh, it's a piece of, not junk mail, but you don't always read it. If you get a detainer for someone, you make sure, I imagine, who is the person. You may not read all the way through every time you get a detainer, but it's clear on the face that you should only hold them for not to exceed 48 hours. But I think the reality is that people are often held for far more than 48 hours, sometimes for weeks or even months on end, while ICE may or may not come to get them. And so that's why the 48-hour is really important to know and I think to enforce, because the longer the person is there, I think the more likely it is that someone is going to call ICE every day until ICE comes to get that person. So I think that you can presume they don't know and you can sort of politely inform them, but they should know. And it's there on the face of the document. And you have the regs as well to back it up. And I have, to the extent it comes to filing a habeas petition for someone, we have samples of those because the public defender's offices in LA have had to do that.
My main county, which is just southwest of Lincoln, we actually, our jail has a contract with the Marshal Service and with ICE, and as a consequence, when they bring them into court, my first question is there an ICE hold? And if they say yes, then I just PR them out and they keep them and then they charge the federal government.
And so this goes to, this story goes to the fact that a lot of the immigration enforcement detention will happen and holding them will happen in state or local facilities. And so often you'll have someone with an immigration hold, but when the hold is triggered, the person may physically not go anywhere different. They might transfer to a different part of the jail, or they may stay exactly where they are. In that kind of case, the 48-hour rule technically would apply, but the reality is that unless there's some snafu, the person will be picked up by ICE because ICE will simply have to change some paperwork to make them under ICE custody, but they're not going to have to actually physically transport them
The
somewhere.
other problem we have to go to juvenile court is when it's the parent that they picked up.
Right,
And the next thing we know, the parent is in some facility north of Des Moines, Iowa.
exactly.
And then you've got to go to the district court in our county to get an order to authorize our sheriff to go to north of Des Moines to pick up that mother, to bring her back to juvenile court, and then drive her back.
It's a really, this story goes to the difficulty when you have enforcement actions against parents and the reality that often parents are transported outside of Nebraska to often far-flung places that make it very difficult for them to meaningfully participate in any kind of juvenile case that may be going on. And so after we talk about the apprehension and removal, I'm going to talk to you a bit about ideas for what you might do when you're handling a juvenile case where the parent's detained by ICE. Some ways to be able to contact the parent, some ways to be able to communicate with ICE to try to the extent possible to maximize the parent's involvement in the cases. But the reality is that some parents will be held locally, but sometimes parents may be shipped far away, and there's no rhyme or reason. It's not that they're being shipped near their aunt in Peoria, it's that they're just shipped where there's an empty bed, or they're shipped where there's a facility that, houses women and this is a woman. So it's very difficult because once they get into the ICE system, it's hard to keep them in one place. And ICE feels that they have a lot of control, and they do, over where they send people. But I'll give you some tips on if you have an open juvenile case. ICE is getting a lot of heat right now about how they are separating families. And so I think there are ways to not pressure, but ways to communicate with ICE that can help you to keep people locally. It may not always be successful, but I'll give you some ideas about that. So this is the detainer, the rag we talked about. Just some tips that people might want to know about the right to remain silent in the face of their questioning, and that DHS can use information to establish people's portability simply from an interview, including from an interview from children. So I am currently representing a 12-year-old diagnosed with mental retardation who was placed in removal proceedings based on an interview that was conducted with him by an ICE officer with none of his attorneys present. And the government has said he admitted he was born in Mexico, and so, we're sending him back. So it's something to be aware of. There is not a cutoff. They can interview 7-year-old children and start a case based on their admissions as well. So just to be aware of that. Yeah. So I'll talk just for a minute about what happens if a child is picked up by ICE. Usually if the child is deemed accompanied, she may be released to a parent or guardian, could be kept in ICE detention. Accompanied means that there's a parent or guardian here in the US willing to provide care and protection. If the child is a state ward of Nebraska, what I would want to do is get in touch with ICE right away and have the child just released back into your custody rather than the child going into the federal detention system where you're going to have a lot of work to do to try to get that child released. Because they will want to release the child to you generally, but you're going to have to fill out massive amounts of paperwork to do it. So if you can just get them early on before they make it into the federal system, the easier it will be. If the child's deemed unaccompanied, and this is often the case for children who are picked up at the border or maybe some internal enforcement, but they have no adult around, then typically they're going to be kept in federal custody and they will be sent out of Nebraska because there is no office. This is the Federal Office of Refugee Resettlement that houses these children. And there are no ORR facilities here in Nebraska. So if a child is picked up and taken into federal immigration custody, the child will not be placed in a facility here. It's likely they could go to California or Oregon or Illinois, Indiana. And again, there's not a lot of rhyme or reason where the child would end up geographically. If the child is in ORR care, ORR does have an obligation to try to release the child hold the child in a least restrictive setting and try to release the child to a responsible adult to care for the child. Sometimes there are some difficulties because you might have a grandmother perfectly able to care for the child, but she's undocumented and she doesn't want to come forward and be involved with ICE because she may be concerned, or even with ORR, that somehow her immigration status may get on the radar of the federal government. So sometimes you have children who languish or stay in federal custody even when there is someone to care for them because the person is concerned about coming forward. So certainly if you're the state agency and you're able to prevent the child from going into that part of the system, there won't be monitoring of the immigration status of who the child is ultimately placed with, but just to be aware that it's certainly something that, that can be a concern for families. The process is radically different if ICE picks up an adult. There's no friendly Office of Refugee Resettlement involved. Instead, you have an ICE officer who's going to make an initial determination about detention versus release. It is also the case that there may be some initial determinations, for better or worse, about whether someone wants to stay and fight their case or whether they want to just sign a voluntary removal order and get out of the United States. Many people do sign these voluntary departure, voluntary removal orders because, for example, they have children here, they have no one to care for the children, they don't want to be detained because they're concerned that it could lead to harm to the children or their inability to work and support their family. So you will certainly have people who opt not to stay and fight and instead who will leave. And I think in the example from 2006 of the raid in Grand Island, 6 months after the raid, you had a small handful of people who were still in detention fighting their cases, and that the vast majority of people were gone. And some of them had been deported by the government after immigration court hearings, but many of them opted to sign off on their deportation and leave right up front. So it's something to be aware of when there is a raid, if their children come into the system as a result. If they choose to fight their case, like we saw today, I mean, it could go on for years. But if they choose not to fight their case, it may actually be a very limited, potentially limited amount of time that the person is here before they're gone. And so to the extent that anyone is trying to get legal services to them, the sooner they get it, the better, because some of them may have made some decisions that could be pretty quickly acted upon. The government recognizes that generally they shouldn't be spending detention resources on people who are particularly vulnerable, including pregnant people or people who are the primary caretakers of children. So to the extent that you are representing parents who are in ICE custody and their primary caretaker of children, anything that a person could do to negotiate with ICE for their release would be helpful, or at least documentation that they are the primary caretakers of children. So ICE can release many people to fight their immigration case on the outside, but there are also a lot of people who are subject to mandatory detention. And so even if they are pregnant and are primary caretakers of children and are mentally disabled, they're going to be detained. The immigration judge later in their case may be able to issue a bond for them to bond out of detention, but the lowest bond the judge would be able to issue is $1,500. So sometimes you have people sitting in detention not because they're a flight risk or a danger, but because they may not have the money together to be able to bond out of detention. And like the judge mentioned, those who remain detained may be transferred anywhere in the country. And you have facilities run by ICE, so they're federal facilities, but then really what you have is a patchwork of state and local facilities where people are held. And I think that the immigration detention population is actually the largest and fastest growing prison population in the US. And on any given day, ICE has about 33,000 people in immigration detention. Last year, I think it was about 380,000 people in 2009 that it held. So it's huge numbers, and they're not capable of holding them in large federal facilities. So this is why you'll often have state facilities that contract with the federal government to hold ICE detainees. And I mean, obviously there are concerns about financial incentives for detecting and detaining people, but the reality is it's hard to know when an adult is detained where that person is going to wind up. Going over the removal procedures, if the person decides they're going to at least try in some initial way to fight their case, then they will be put into immigration court proceedings. They'll receive a notice to appear, which is the document you saw earlier. It's a charging document for immigration court. Even if it's a child, there's no right to government-appointed counsel in removal proceedings. So if you can afford a lawyer or you can find a free lawyer, then you have the absolute right to bring that person to immigration court. But you have no right, whether you're mentally disabled or a child or an adult, to have the government appoint counsel for you. So this is part of what's sort of interesting. When you go to immigration court, you have the judge, an attorney representing the federal government, and then many times a pro per person, often who does not speak English, trying to represent themselves in the proceedings. So it's unlike criminal proceedings or even some state child welfare proceedings where you routinely will have appointment of counsel. Yeah.
I thought you mentioned earlier that the judges may appoint counsel, so they have the discretion to?
This would be your state court judge, if your state court judge is willing to do it. The immigration judges don't have the authority to appoint counsel. And so we actually have a lawsuit pending right now against the federal government related to right to counsel for people with profound mental disabilities who also have no right to counsel and who are clearly impaired from representing themselves. If anyone wanted to volunteer to represent someone in immigration court, or if the court were willing to find or get pro bono counsel or paid counsel, the child can absolutely, or the parent, have that lawyer, no question. But the federal government is not going to foot the bill. And so it becomes hard to find those people, but certainly they have the right to have them if they can afford them. Person will go before the immigration judge multiple times, and over the course of several hearings, the judge is going to figure out whether they stay or go. Yes?
Okay, just a random question. When you say they have no right to counsel, is that undocumented, or what if they're a legal permanent resident?
They have no right to government-appointed counsel. So they have a right to counsel in that they have a right to bring a lawyer for representing them. But they don't have the right to expect the federal government to pay for it. And that's the case whether you're a permanent resident or whether you're undocumented. It's the same rule across the board. If you're a permanent resident, I think the honest reality is that you may have more financial resources depending on how long you've been here. Maybe you could more likely afford to hire a lawyer, and you do have the right to have the lawyer. You just don't have the right to have someone else pay for the lawyer. So like I mentioned, there will be several hearings before the immigration judge where the judge decides two things. Is this person removable, and do they qualify for immigration relief? And so if the judge finds them removable, meaning the government has shown enough evidence that they do not either have lawful status here or that they're permanent residents but they're deportable, the burden then would shift to the applicant or the respondent to prove that they have some way nonetheless to stay here. So if you're a US citizen, you don't know it, you learn it, you want to stop your case at the removability phase. You want to say, I'm not removable, I'm a US citizen, and that may work. If the judge decides, you know what, you are removable, you're undocumented, you get to the relief stage where you can assert any kind of immigration relief that you have. And so the things we talked about this morning, asylum, U visa, you could pursue, the immigration judge cannot grant the U visa, but you can pursue it with the immigration service while you're in removal. SIJS, a child could pursue family-based immigration, VAWA relief. This is where, for people in removal, those kinds of relief come into play. They can actually try to pursue them in the course of the removal proceedings. Again, it can be difficult if the person's detained. They may have a hard time filling out applications, getting supporting documentation, and they also generally, I think the people who are detained are on a bit of a shorter time frame of adjudication of their cases because the government is paying every day to keep them locked up. And so I think that there's a general sense that those cases may move along more quickly than others.
As a general practice, if you have someone that's detained and you can get them out on bond, you definitely want to do that, because if they're detained, they get paid.
Right.
In these local jails that are doing this for the federal government, $100 a day for each individual. So ISIS attorneys are heavily persuaded by the higher-ups to quickly, if you're detained, quickly adjudicate them. Now, if your client is lucky and can get out on bond,
Right.
never admit or stipulate to anything, because my experience has been immigration always gets at least one of the allegations wrong, if not two.
Right.
And then I have a case now that there were two brothers. One brother had a drug conviction, so he was not bondable. So he's gone. His other brother, never been in trouble, came here, under a work visa, overstayed. He's still here.
So I think that this anecdote goes to the fact that to the extent that it's possible to get, with children who are detained, the chances of them being released are actually pretty good. If someone steps forward, there's no bond problem, you're probably going to get the kid out of detention. If it's an adult and there's any way the person can bond out, it's, I think, highly recommended they do so, partly for their immigration case. It removes the impetus to adjudicate the case very quickly. And partly because when people are out and not detained, they're more able to fully participate in the cases you guys are dealing with, which are whatever juvenile cases may have arisen as perhaps as a result of the adult's detention. And so whether at the end of the day the parent has to leave or go, their ability to participate in the proceedings, to prepare for any deportation they may have, to make plans or decisions about what's going to happen to the children is much easier and more effectively done for everyone if the parent is not locked up by the federal government. Go ahead.
I heard of a case where, it was a neglect case, where mama got detained, and then during these hearings, HHS actively came in and testified against her to get her deported.
So it's a sad tale, but it's the example was that HHS may have testified against the mother in one of these removal proceedings. That certainly is possible, and it could happen by subpoena from the federal government, but alternatively, you could have people from the juvenile court side in there testifying in support of forms of immigration relief for the parent. So if you...
My sense was there was no subpoena, it was just somebody being helpful.
So helpfulness can cut both ways, and there are situations where, particularly if someone has an immigration lawyer, they might call upon some of you to participate in the cases, hopefully in a way that could be ultimately beneficial. But just to be aware, the rules of evidence don't apply in immigration court, so you can be very creative in the kinds of evidence that you are dealing with. And sometimes that can be very helpful, but sometimes it's not incredibly helpful. Thing to know is that a child's being a state ward doesn't prevent her from getting a removal order, doesn't prevent her from being removed. The federal government, while on the PR end might be concerned about that, there's nothing legally that would prevent them from removing a ward. Similarly, a parent having a US citizen child, like we talked about before, not going to prevent the parent from getting removed. And a parent having a pending state court case where their parental rights are at stake, also not preventing them from getting removed. If a person doesn't show up for immigration court, they will get a removal order. So if you have a child who comes into state care and you know they're in removal proceedings, you want to figure out when and where the next hearing is, because if the child does not show up, then the child can get a removal order. And there's a handy 1-800 number. It's 1-800-898-7180. That's the 1-800 number for the immigration court. If you know the child's A number, you can pop it into the system and it will tell you when their next immigration court hearing is and where it is. And that's the case for adults, but also for children. So it's one of the fairly automated ways that the courts are handled. If ultimately at the end of the day someone is ordered removed, then and they're not in federal custody, they'll get a bag and baggage letter basically saying, show up on this day for your deportation, you have a limited amount of luggage you can bring, and here's when you should show up. If they're detained, then obviously they're already in the control of the federal government in some way or another, whether it's in a local facility or not. And so the rates of effective removal of people who are detained are high relative to people who are not detained when the removal order is issued. The person does have a right to appeal their removal order to the Board of Immigration Appeals or to the Court of Appeals, or subsequently to the Court of Appeals for the federal circuit where the person's immigration case was heard.
Can you say that number again?
Oh yeah, 1-800, let me have it here, 870, I'm sorry, that's my other number, 898-7180. And again, this is, if a person has an asylum claim or some other kinds of claims, their A number might not reveal the information because it's a confidential case. But generally speaking, you can find out that information. It'll tell you the date and the type of hearing, whether it's a merits hearing or it's just a scheduling or master calendar hearing. It'll tell you where the hearing is taking place.
You might want to, besides just calling the 800 number, that it should tell you what court.
You can call the court.
Call the court
Yeah.
to double check that they got the right date and the right time.
Right.
Immigration, sometimes the right hand doesn't know what the left hand's doing.
And particularly if you're going to be transporting a child to court, it probably is a good idea to confirm that so you don't spend a lot of resources taking a long drive for a court hearing that is rescheduled or not going to happen. So just some ideas, I think a couple ideas for the kind of assistance you might be able to provide to a child who is in removal proceedings, recognizing that your role may be squarely in the juvenile court and you're not taking on the representation of the child in immigration court. But to the extent that you could help facilitate the child getting in touch with the free legal services providers, that would be great. If the child's a state warden, there's any way to help facilitate their release from the Office of Refugee Resettlement, that is a good idea. And you can always contact me. I can give you contact information for the ORR people in DC who are pretty responsive to working with state agencies. If there's some kind of immigration relief that could have a juvenile court component, whether it's SIJS or a U visa certification, certainly helping to facilitate that would be useful. Even getting juvenile court documents if the families need it or the child needs it. And to the extent that the child picks up another delinquency case or some kind of case while the removal proceedings are pending, to just be aware that there are removal proceedings and try to work on resolving the delinquency issues in a way that would be least damaging to the immigration case, recognizing that sometimes that's not possible. If it's parents or adults that you're trying to assist, some of the things are the same. The referrals to free legal services providers, to the extent that there can be any help in facilitating release from detention, even if that means just providing information that substantiates that the person is a primary caretaker of children, that may be very helpful to getting the person released from detention. To the extent that the immigration attorney, if there is one, needs help in gathering evidence for an immigration claim. And then if there is a determination made at the end of your juvenile case that the child will be returning to the home country with the parent, making some attempts to coordinate the return of the parent and child, which usually means not being able to negotiate that much with ICE on their timetable, but at least learning what the ICE timetable is for removal and trying to schedule and coordinate things on the juvenile court end. These are some pretty specific tips, some of them are, on working with cases where you have a detained parent. And after I go over that, I will just give some general ideas for immigrant families in juvenile court. Locating and communicating with the parent, I think, can often be a real challenge when they're in immigration detention. And up until, I would say, maybe 6 months ago, it was almost impossible to figure out where people were held. And so ICE now has created a detainee locator, where with the person's name and, I think, country of origin, perhaps if you have the A number, that's particularly helpful, you can go online and do a search and find out where the person is being held. So to the extent that you are representing the person and need to find them, or the extent to which they need to be given notice of certain juvenile proceedings, there is a mechanism now to locate these people. And if you enter the information on the locator and the person doesn't pop up, don't presume they've been deported, although they may have been. What you will do is there are phone numbers listed online. You will call a local ICE office, a deportation officer, and you can inquire about the case. I think that there are, ICE has some concerns about releasing too much detainee information, but I think if you're the lawyer for the person or a state agency that's working on a case, I think you'll have better luck in getting information. If the person has family members, a spouse or someone, that person might also be a good person who could make the call. But again, at least there is some way to locate people. You do want to recognize that it's really difficult often for people to communicate while they're in detention. So the fact that they haven't sent you 20 letters or called 20 times is not necessarily an indication that they are uninterested in what's going on in state court. There are real difficulties that may be inherent in their detention and also may vary facility by facility. How expensive is it to call out? Do they have money there? Can they make calls out? Can they collect calls? Are they able to write? Can they mail things? And so you just want to be aware that people have some limited ability to communicate, and what you may want is to be in close communication with the deportation officer who's assigned to the detainee. Everyone has a deportation officer, even if they're not ultimately deported, and there's somebody in ICE responsible for that person, and that may be someone that you would want to know who they are and get information from them about how to involve and give notice to parents. In terms of ensuring a parental involvement in hearings, again, it can be really challenging. I definitely recognize that. I think that ICE, like I said, is coming under a lot of heat for the way that their detainees have been treated vis-a-vis their state court cases. And so ICE operates under something called the Performance-Based National Detention Standards. And the version that came out in 2010 that's not fully implemented yet actually has a specific provision allowing for transportation of people, adults, to participate in state court proceedings at which their parental rights and custody of their children are at stake. Some of the ICE offices may not know about this, but it's something that you will want to be aware of, because I think that you can try to facilitate video participation of parents, but also physical transfer of them. There's a woman, I'll give you her contact info, There's a woman named Emily Butera. She works in Washington, D.C. at the Women's Refugee Commission. And she's been a point person for working and talking with ICE about problems that come up when parents are unable to participate in state court proceedings. And so she has offered to be a contact person. I think actually, I don't have it here. If you email me, I can give you her email address. And this was as of November of last year. She offered to be a contact person. If you try to negotiate with ICE to have a parent involved in a hearing and you're not getting anywhere, she will go to someone at a higher level in Washington, D.C. and raise the issue with them and try to resolve it. So if you try locally and you're running into problems, there are ways to do some advocacy without a lot of effort on your part to get this woman involved to help advocate in your particular case. And again, the performance-based standards are telling ICE that they need to be able to transport people to these hearings, but unfortunately, it still is at ICE's discretion. There's nothing that tells them you have to bring people or facilitate their access, but I think that ICE is concerned enough about this that it's worth having those discussions. To the extent, and this I think I talked to people in break about this, it can be, I think, challenging to develop case plans for detained adults because so many of the things that you would think they would be doing if they were undetained, and which is a reason to get people bonded out, but the things that may be expected or hoped for in terms of visitation with children, regular phone contact with them, the ability to access parenting classes or any other kind of classes is going to be really limited in immigration detention. There are usually no contact visits at all in detention. If the child is undocumented, you're not going to be bringing the child to the facility. And so the kind of things that come up in, I think, cases where adults are detained on criminal charges and the kind of hurdles there are can be even greater, I think, once the person enters the federal immigration system. So I think it's just a plug or a hope that the realities for the detained parents are taken into account when a case plan is being crafted, and that the parents' inability to comply with some of the general requirements you might have may not be, while maybe linked to a prior decision by the parent to come here, are not linked to the parent's active decision while they're detained by ICE. And so more generally on working with immigrant families in juvenile court, I mean, this could be like a 5-day CLE that someone else would do for you, but I just want to raise a few issues for you to be thinking about. And one of them is the involvement of the foreign consulate and the notification of the consulate when you have a foreign-born child involved in a juvenile case. But I think more than just the sort of pro forma notice, the idea that the consulate may actually be somewhat involved and helpful to you is something I would say you should be open to. And I think we have someone here who has spoken with the consul, the Mexican consul here in Omaha. Do you want to just tell people what you learned?
Well, I mean, just going back to getting information, like birth certificates and whatnot, like I've talked to consul and he's reassured me that you can get any sort of government information like regarding like live birth and whatnot from the consulate. And it doesn't sound like it takes too long. I mean, I'm sure it's probably phone call, email.
And do you work for HHS or do you work for some?
No,
you don't.
work for-
Okay, got it. Okay, got it. So this is a good sign because even someone who's not working for a state agency can have these direct conversations. I would say that state agencies really can also work with the consulates, and if they're open to not just providing documentation, but there have been cases where consulates have helped to arrange for legal assistance for people, legal representation for people in removal. Have helped with obtaining identity documents for children. So I would say that it's certainly worthwhile, not just that it be notified as a matter of course, but really thinking about the extent to which the consulates may actually be a resource for you. And again, I would say that often approaching the consulates, not just on a specific case, but trying to sit down and have a more general conversation with them may be a good way to go. Go ahead.
And if the child is a foreign national, consulate, they has to be notified
Yes.
by the state.
Yeah, and I think that was an issue in one of the Nebraska Supreme Court cases somewhat recently about notification, and I think that's where the quote I have here is about the agency's obligation to do the notification, but also the recognition that it's not the agency alone that should be concerned about that, but it can be the juvenile court or the guardian ad litem who needs to be aware of and taking into account whether the notification has occurred. So that's from the Nebraska Supreme Court. To all of you. Translation interpretation, they're big issues. we have someone who has interpreted here, and I think that there are just a few things to keep in mind. One of them, I would say, can be important is courts' recognitions that the communication is actually an essential part of due process for families, any families, but non-English families as well. And so I think that the due process requirements in court may be implicated. Also, for those of you who are attorneys and who are bound by ethical rules of conduct and professional rules that govern your own duty to communicate with your client, it's not just the duty to communicate in a way that you understand, but it's a duty to communicate in a way that your client's going to understand, and for you to be able to actually understand what your client is telling you. So one of the ways I think that for us frequently comes up, or may, and something that's not always readily apparent, is that particularly when you're working with indigenous clients, very frequently clients from Guatemala, who may actually have a native language of Quiche or Canjobal, they may actually have very limited Spanish abilities. And you might think, well, they're from Guatemala and everyone speaks Spanish there. It is true that that may be the general case, that it's the national language, but there are quite a few indigenous and varied indigenous groups in Central America and Mexico that don't have Spanish as their primary language. And so sometimes if you feel that you're having a communication problem, it may be not that your Spanish interpreter is not a good interpreter, it may be that the person who is communicating in a kindergarten level of Spanish. And so sometimes you may have much better luck if you understand what the person's native language is and have the ability to get interpreting services in that native language. There are difficulties. In LA County, there are like 2 Quiche interpreters for the whole county. There can be some real challenges in arranging that kind of interpreting. Also, confidentiality issues may come up because sometimes the indigenous communities are small, and if you use one person as an interpreter, unless that person understands confidentiality provisions, you may have real concern that the information that's being expressed is going to be spread around the community. I think a lot of places have ultimately had to choose to rely on telephonic interpretive services for the more obscure languages. And it's not ideal. I think a lot of the interpreting is important that we all be physically in the same place, but if that's not possible, then the second best alternative is to have someone who can be a telephonic interpreter in a language that's going to be ideal for the family. And again, just a couple tips about confidentiality, and also not using children as interpreters is an important thing to keep in mind. It can seem really easy and convenient, but you want to be really careful about a child's ability to not just to grasp language, but the content of the conversations you're having, and the child or parents' complicated feelings about the child's role in interpreting what sometimes can be kind of damaging information. So just be aware that while it can be, and I am often tempted to do it, it can be a tempting yet not advisable approach. This is one slide, cultural competence and sensitivity, but I think that there are many organizations that have spent their entire professional existence dealing and addressing this issue, and actually specifically in the area of child welfare. So there is an organization called BRICS, and I put the info on the resources section, but it's Bridging Refugee Youth and Children's Services. They have amazing resources, expert technical assistance, and their whole focus is on immigrant children and families and the intersection with the child welfare system. And then there's also a group called the Migration and Child Welfare National Network, and their information is in there. And their organizer wanted me to put in a plea for people in Nebraska to join her free organization and get information about immigration issues for families and child welfare. So what I would say is that there is a whole world of resources you can access. One thing that I think does come up and that is worth just keeping in mind is that often families' experiences with authorities in their home country may transfer over to the United States in ways that may be surprising or confounding. That it could be that there's a complete lack of any kind of child welfare system in the country that the family comes from, and so they see child welfare as police, and that's all they are. They may have also just had bad experiences with authorities, whether they're judges or police or child welfare in their home countries, and so they may not have a clear sense of what the US legal system looks like, how it works, or what the function of these proceedings really are. And so I would say that taking a step back and trying to perhaps understand or think about what they're coming to the table with in terms of their concerns about the system, some of those concerns that may end up looking like a reluctance to participate may simply be fears that have been created way before the person even came here. And so to at least be able to acknowledge those and perhaps address them in some way that is probably not super complicated, it may go a long way in terms of helping both parents and children who find themselves in these situations. And as a aside, I think I didn't say this earlier, but for children that you're helping to apply for immigration benefits, it's really important for the process also to be explained to them, because many children, if you tell them you're taking them to the immigration officer, they think they're going to be deported. And unless you're really clear about what's going on, you may have a very distressed individual on your hands. So that's just a plug for some transparency. So I'm going to take a drink of water, and then we're just going to spend about 10 minutes going over the resources that I put together, and then we will be done. There are a lot of materials on SIJS that are available. Most of these things that I'm putting here are all free, because the reality is that if you could ever find a least funded area of immigration law is for abused, neglected immigrant children. So a lot of these things that I'm putting up here are things you can access absolutely for free, because we've realized if you had to pay, then many people would not be able to. So you can download a lot of these things for free. There are materials on SIJS at the Immigrant Legal Resource Center, some PowerPoints, some materials that you can access there. There's also, the Immigrant Legal Resource Center has created a immigration bench book for juvenile and family courts. And so it's designed specifically for juvenile and family court judges to give overviews of a lot of what we've talked about today, but also really written specifically for an audience of judges. And that also is available for free as a download on the ILRC website. There are some resource libraries, National Center for Immigrant and Refugee Children, some SIJS specific information here. And then like I mentioned, this is the information for BRICS, and they have the child welfare / immigration technical assistance, and you can access and request that online or by sending an email into BRICS. There are also the Lutheran Immigrant Refugee Services has a really great publication on working with immigrant children. This is not specifically about applying for immigration benefits. It has more to do with tips for interviewing immigrant kids and getting some more background on sort of how they may understand their life in the United States, and things that you could probably do in your own practice to make your relationships more effective. Here, there's a publication. Annie Casey has been really involved in looking at issues for immigrant kids in the child welfare system, and so they have an initial publication, I think that was back several years ago, that looks generally at the issue of immigrant families and children in the child welfare system. We also have some reports, Migration, Critical Issue for Child Welfare, and some other immigration materials that have been collected by Family to Family Initiative. This slide is mostly for social workers. This again is available through the Migration and Child Welfare National Network. I actually think that these materials are incredibly helpful whether you're a social worker or not. But they're toolkits that are designed for people who are working within the child welfare system. Some of them are basic, child welfare flowcharts, but then also some basic information on immigration status, immigration options. And then the most recent one that they have is a toolkit for working with immigrant families, and I think with some focus on psychological services for families and issues of trauma in immigrant families, and some tips on how you might treat that a bit differently, or some things to know that may present themselves differently than they would maybe with a family of US citizens. There's also the Women's Refugee Commission, and a couple of other organizations have done a lot of work on exactly what I think a lot of you are maybe facing in some cases, which is a separation of families, not necessarily based on active abuse, neglect by the parents, but because of immigration enforcement actions. And some of these reports are the things that have made ICE a bit more concerned about being responsive to requests for involving parents in the juvenile proceedings. And so we have a pretty recent one from 2002, a couple from 2010, and then a couple of materials from 2009. The last one from Appleseed is not a study about immigration enforcement. It's actually a resource for people who are facing deportation, and very practical advice about if you're leaving the country, what kind of things would you need to do to wrap up your life here before you go, in terms of financial issues, closing bank accounts, selling homes, making sure you have your children, getting things in order. And so it's kind of an unusual publication, but certainly if you're representing a parent who may end up being deported. There's not really anything else out there like this as far as I know. And then the part that I'm hoping will be the most helpful to you are these local resources. And again, I compiled them 2 years ago by calling everyone around the state of Nebraska, but I did have someone review the resource list again just several weeks ago. So I believe that it's still up to date and the people who are listed should still be where they are. But do know that if you do call, there's a chance that you may need to get an updated person or an updated phone number. But again, I've included people who have handled SIJS cases, and so Diana, who's at a nonprofit. We also have Kevin, who's at University of Nebraska, and then I've listed at least one private immigration attorney who has experience doing SIJS cases. And all the people I've listed here have agreed for me to put them here, so they may not know you're going to be calling, but you should feel free to call upon them because they were actually very happy and interested that people who work in juvenile court would want to be reaching out to them on cases. So I hope that you will be able to do that. And then I've just listed a lot of other organizations, and I've tried to put places where it covers what kind of immigration cases they handle. So I've tried particularly on the U visas to focus on those, but really anything they do I've included. So we have Catholic Charities, Nebraska Domestic Violence Sexual Assault Coalition has locations in Lincoln and Lexington, and they handle these U visa and VAWA cases. We also have Center for Legal Immigration Assistance in Lincoln, and that also has a clinic in Lexington. University of Nebraska College of Law Immigration Clinic. God bless them. They're the only people on the immigration court's pro bono list when it gets handed to anyone in immigration court and it says, who can represent you for free. They're the only people who are listed, but a lot of other people do pro bono work, they're just not on there. But they definitely, Kevin has handled SIJS cases with the clinic, so he would be a person to talk to. And there's also Lutheran Family Services, which has, I put SIJS twice, they have offices around the state that you can call upon. In Grand Island, St. Mary's Cathedral, for representation of DHS detainees without criminal issues. So sadly, that may not be a huge proportion of people, but at least there are some resources for a volunteer lawyers project. And then we have the Benedictine Mission House in Schuyler and some Catholic Social Services in Lincoln. And then a couple of these resources here are Nebraska-specific documents. The Nebraska Appleseed does have some resources on their website. There was a study that I referenced earlier that was done about the raid in Grand Island. And honestly, Grand Island comes out looking pretty good in that report when the authors of the report went to Grand Island 6 months after the raid and found that no children had entered the foster care system as a result of that raid, that there were plans in place for children to be cared for in a way that didn't involve or make the state get involved. And really kind of creative work by the school district in Grand Island and others who came together in the face of the raids. I think there were maybe about 300 people who were arrested in that raid. So this Urban Institute report is interesting, and it contrasts what happened in Grand Island to a raid that happened in Colorado and also one that happened in Massachusetts. And then we have a few more resources from University of Nebraska, some immigration controversies in Nebraska, and then also some strategic discussions about immigration. These things are actually ongoing. I think that on the 18th of April, there was a panel that happened, I think it was in Lincoln, and it was sponsored by the journalism school at the University of Nebraska, and it had a panel of people discussing immigration issues. So the discussions are alive and well here. And then the last thing that I have listed here is the book that I referred to earlier. It's just a really interesting book about refugee families and communities, particularly in Lincoln. And this woman is a really great writer. It's almost 10 years old at this point, but for any of you who are sort of interested in getting a different look at immigrant experiences or refugee asylee experiences, it's actually a really wonderful book to read. And sort of gives you a different perspective on Lincoln, I guess, if you're not familiar with that part of the city's history. So after these slides, I'm not going to go over them, but I just do want you to know that they're here for you to read. I've included a few slides at the end about ideas for how juvenile court and child welfare, everyone working with children, may have some ideas about how, to the extent that you want to facilitate immigration legal services for kids, different models that are out there for doing that and different ways it might happen, whether it's in the dependency 3A side, delinquency, or through the independent adoptions or guardianships. So all of that is, all of those things are in the materials. And I think we are 3 minutes under our time, and we're done. If people have questions, I'm going to be here for a while afterwards, but really I do want to encourage you to feel free to call or email me. I still get, I went to Indiana 5 years ago, and every so often someone from Indiana will email me, and it makes me very happy. So I hope that you can see me as a resource going forward if you want and need that help. So Kelly, do you need to come up, or are you good?